Chris comes to us from VerSan Consulting. Thank you for joining us today. Chris has a really deep understanding of the fiduciary role that health plan administrators hold and that they should be leveraging to drive value for their plan sponsors and members. So she's an attorney by training, which is great because that's a key piece of helping employers understand their fiduciary role. And her goal is to really educate and engage employers to be more prudent purchasers of healthcare. And so I think today she wants to talk to us about large employer health plans and what they have an opportunity as well as an obligation to do to drive healthcare transformation that really delivers value for the market. Chris, I am going to go ahead and let you dive into your presentation, if that's okay.
Sure, great. And just another quick note about my background. As Christin said, I'm an attorney by training, but I was previously in the public sector with the state of New Jersey, running their public sector health plan for about 820,000 lives across our active and retiree population and their dependents. And that's what I would say really gave me a deep understanding of the role of the purchaser and being a good steward of your health plan's funds, and in our case, taxpayer dollars as well. So we'll dive right in. Again, feel free to put questions in the chat. We can stop as the presentation's ongoing. It's really intended to be kind of a workshop as well. We're getting into some really practical things that you can do as health plan administrators. So welcome any questions. Next slide. All right, so just quickly, we're going to cover what I refer to as the fiduciary framework, and then sort of executing on what that means for the health plan fiduciaries in the room. As you engage in this journey of really fulfilling that fiduciary obligation, you're going to need to identify allies and those that potentially stand in the way of you fulfilling this duty. And then we'll open it up for questions and discussion. Next slide. Okay, so first, I think one of the most important questions we have to ask is, am I a fiduciary? Have we identified the fiduciaries in our health plan? And then obviously, what does it mean to be a fiduciary and how do I execute on that? It's really important. I think I heard Christin say that she's also responsible for the retiree side, or the pension side as well. On the pension side, this has been something that we're sort of used to and have been used to for the last 10, 15 years. And whether that's through a fiduciary committee or very express like fiduciary rules and roles that have been set forth in governing documents. And on the health plan side, that may or may not exist in your organization, but it should. There should absolutely be a very clear understanding of whether you are a fiduciary, whether that's named in plan documents, and then whether your vendors are also acting in a fiduciary capacity. We'll talk a little bit more later in the presentation about named fiduciaries versus functional fiduciaries. But again, the important point here is the first thing is really determining if that's a role you fill. And if you didn't know you were filling it and you are, it's really important that that gets memorialized somewhere. And that you carry the correct, directors and officers liability policies that cover fiduciary liability. Next slide. Okay, so this document is actually, it's from 2018. That's what it's dated, from the Department of Labor's website. And it sets forth the 5 key fiduciary principles for health plan administrators. I think it's really important to level set that while we'll talk about some new statutory laws and regulations that have recently come into being that affect fiduciaries and the fiduciary role you play, the bottom line is fiduciary obligations have been part of health plan administration for many years. And they predate the Consolidated Appropriations Act. They predate, a lot of folks are talking about this right now and using sort of the fiduciary hook. Some I've even seen it as a sales pitch, right? We can help you fulfill your fiduciary this or that. But it's really important to know that this is a standard that has existed for quite some time. There are some new tools out there and some new requirements, but these really undergird your fiduciary obligations. So you have to act in the sole and best interest of the plan, carry out your duties prudently, follow plan documents, hold plan assets in trust, and pay only reasonable plan expenses. Very simple concepts, very complex and difficult to execute on certainly in the environment before we had access or greater access to data like the SAGE transparency tool and others, but still a heavy lift nonetheless. Next slide. Okay, so there are resources, as I just mentioned, to help your organization establish who is a fiduciary. So more and more, there's purchaser coalitions putting out white papers. So whether that's the National Alliance, your own forum, PBGH, there are increasing numbers of fiduciary checklists, some of which I've published or contributed to help you identify who is a fiduciary of your plan. And then also you can see a little screenshot here. The Department of Labor is issuing guidance as well. And that's, always a great resource to go right to the source to seek their guidance in who is a fiduciary and what that means. Next slide. Okay. So you heard me earlier reference the Consolidated Appropriations Act, and it's probably, I hope, something you've heard of. If you haven't, no problem. The Consolidated Appropriations Act of 2021 has buried deep in the bowels of the 2,000-page document 2 sections that are particularly relevant to ERISA-funded, ERISA-sponsored health plans. Section 201 amends ERISA and the Internal Revenue Code to require employer-sponsored health plans to ensure that you have access to certain cost and quality of care information. We're going to talk a little bit more about what that means and some of the specifics, but this is a section that really gives you some great tools and leverage to use with your carriers and service providers to get greater access to your data. Section 202, you might have heard about the broker consultant comp disclosure rules. That's what this section is. It requires that any compensation paid to a plan service provider be reasonable, and they have to disclose both direct and indirect compensation. So for example, if you have a broker who is paid a bonus by a carrier, let's say Blue Cross Blue Shield, for keeping a certain number of lives with that carrier year over year. So let's say the goal is 100,000 lives, and your company makes up 50,000 of those lives for that broker to hit a bonus. That's compensation that has to be disclosed to you, and they have to attest that they have disclosed all of the compensation, both direct and indirect, as a result of your business. Next slide. Okay, so this looks a little wonky, but I think it's really important. I actually went in to the 2,000-page document and pulled out the actual text, and this is section 201. Note that it's titled transparency, which is important when determining intent. But this is probably, to me, one of the most meaningful changes in the law for fiduciaries, because it really gives you the tools that you need to really execute on that obligation. It's also a provision that is still very much being batted around, if you will, by self-funded employers and carriers with respect to what it actually means. Despite the fact that the statute is pretty clear on its face, there are still some debates going on as to the reach of information that this clause gives you. So a group health plan, and I'm just going to read a little bit of highlighted, a group health plan, so an ERISA-sponsored health plan, cannot enter into an agreement with a network or association of providers or third-party administrators. So again, a group health plan cannot enter into an agreement with a TPA that would directly or indirectly restrict a group health plan from electronically accessing de-identified claims or encounter information. So what does that mean? First, I think it's important to point out, actually next slide, we can go to the next slide, that this provision is directed to the employers, right? The employers now have the onus on them that they can't enter into a contract with a TPA or a carrier that precludes them from gaining access to their claims data. Actually, Christin, if you wouldn't mind going back, because I think there's one more section that I wanted to, okay. And when we say claims data, right, I've also seen this debated, okay? So an employer goes to their carrier and they say, I'd like all my claims data. I want to have a third party look at it for, you know, whatever reason. And then they get a file and let's say it has, you know, 10 fields missing, or it's got a paid amount and allowed amount, but it doesn't have billed amount, right? And I've seen, you know, pushback saying, with a carrier saying that, you know, we can't deliver that type of financial information. But you know, the statute itself, and again, I think if you need something to rely upon when you're having these conversations to try and get ownership of your data, you go right to the text. This includes, and so I'm reading from sort of that second column, on a per claim basis, financial information such as the allowed amount or any other claim related financial obligations included in the provider contract. And then it goes on, provider information, service codes, or, and then this is where I'm going to put my lawyer hat on, from a statutory construction perspective, this last clause is what we call a catch-all. It's the savings clause. It's what Congress used in order to sort of communicate its intent that we're trying to be as broad as possible here in this language, and any other data element included in claim or encounter transactions, right? So what that clause does is it's Congress's way of expressing its intent, its clear intent that we're going to be as inclusive as possible to serve the purposes, you know, for which the section is titled transparency. Okay, next slide. So what does this mean for you as a fiduciary? You have to ensure that all gag clauses, and I'm referring to these confidentiality provisions or data use restrictions or anything that you have in your contract that limits your access to your data, ensure that all those clauses have been removed or voided. Ensure that you have access to actually have the access. You have to collect the comp disclosures from your brokers and consultants. You have to actually evaluate whether the compensation that's been disclosed is reasonable and in keeping with, you know, market. with respect to the compensation, with both of these, actually, you're supposed to submit an annual attestation to the Department of Labor to that effect. We got a bit of a reprieve on the detailed reporting on the prescription drug, the RxDC data, to June. But I think I put this presentation before we got that December 27th reprieve. But these are all the things that you need to do in order to be fully compliant with these new laws. Next slide, please. Okay, so what does this mean in practical terms? Again, so three layers down. You can't have contracts that don't give you access to your claims data. You can't sort of stick your head in the sand when it comes to your broker and consultant on just sort of trusting their disclosures on comp and whether or not they're receiving, overrides in the back. Like you can trust, but verify, right? No more standard RFPs or rate renewal processes. Like you actually have to assess what you're paying for reasonableness. And I would say, and this is sort of the counselor in me, document. The more you document the manner in which you're executing on these fiduciary obligations, the better situated you are going to be should it ever be challenged. Have processes and procedures in place, document them, and then finally, you can leverage that data and transparency for the benefit of your plan and your plan participants. Next slide.
Chris, before you go to the next slide, I have a quick question. So the attestation that employers need to sign that they've gone through this process, when is that due for 2023? Is it due in December, or you said something about June as well?
So the June date is they've pushed out the RxDC reporting requirement. That was actually due December 27th, 2022. The attestations are due on an annual basis. And there's, so for 2023, I think it would be the end of the plan year. Department of Labor has issued an FAQ, and I can send this to you, Gloria, FAQ and a guidance letter with respect to Section 202. So the broker compensation and disclosure, they've issued guidance, and it's pretty comprehensive, and it answers a lot of sort of detailed questions on how to do this. Unfortunately, they have not yet issued guidance on Section 201 with respect to attestation, but there are, some of us actively working to encourage the Department of Labor to issue those regulations so that employers have a little bit more to stand on when they're having these conversations with their carriers, and they know what type of attestation to look at. But this will be, so for 2023, I would, take a look at that FAQ for Section 202, and then 201, fingers crossed, be on the lookout for DOL guidance in the next few months.
Okay, terrific. Thank you. And then, so just to clarify, employers were required by CAA to sign an attestation form by the end of 2022, but DOL was supposed to issue guidelines on that, right? And because they didn't, I think a lot of employers are confused. Well, should they have done it? Should they not have done it? Is it kind of postponed until this year? Can you clarify that one?
Yeah,
piece?
so there's three pieces. There's there was a tremendous amount of reporting and that's the RxDC reporting that included some of the additional information that the CAA requires. And that was due December 27th, but there was a bit of a reprieve issued just in time for Christmas. The attestations with respect to brokers' comp, that is, again, on an annual basis that you have to do, sort of continually, and that is going to be due, or is due in 23.
Okay.
There's an FAQ that really answers very specific questions there. With respect to, again, section 201 that has to do with data ownership and access, no FAQ or guidance letter yet, but the law is that one thing that the Department of Labor has said is the law executing, and it's self-explanatory. It says, you know, you can't sign these contracts that restrict your access, and you have to file an attestation. So I think more to come. There's enough confusion in the market that I'm hopeful that DOL will help clarify those questions for employers.
Thank you.
Next slide. Okay, so first, I'm going to pause here for a second and again, go a little lawyer on you because I think it's really important to highlight these two cases that are currently working their way through the courts. You may or may not have heard of them, but they're really important and for reasons I'll highlight. So the first case was filed last year, or I'm sorry, was decided last year. And that's the Mass Laborers versus Blue Cross Blue Shield of Massachusetts. Reader's Digest version, a labor union filed a complaint against Blue Cross Blue Shield of Massachusetts for failing to pay claims correctly, for overpaying claims, for paying pursuant to the wrong fee schedule, etc. Blue Cross Blue Shield of Massachusetts filed what's called a motion to dismiss for failure to state a claim. The grounds for them filing this was a breach of fiduciary duty. And Blue Cross Blue Shield of Massachusetts says, we're not a fiduciary. Our plan documents say you retain the fiduciary status as the health plan administrator, and we're not fiduciaries, we just process claims. And our relationship is solely contractual in nature. There's nothing about our relationship that dictates that we're the fiduciary, despite the fact that, you know, they decide what recoveries to pursue and the prices they set and their network and, you know, et cetera. So the case was actually dismissed at the district court level. The case was dismissed. The judge agreed with Blue Cross Blue Shield, says, you're right, this is a purely contractual relationship. Blue Cross Blue Shield didn't accept any fiduciary responsibility here. Case dismissed. So it's working its way up through an appeal, but the important thing here is in that appeals process, the Department of Labor has done something pretty remarkable, and they've filed what's called a friend of the court brief. They filed an amicus brief in support of the appellant, in support of the mass laborers. And in this amicus brief, they very clearly set forth their understanding, which is really important for us, their understanding of what it means to be a fiduciary and who's a fiduciary. They take the position that because the carrier exercised discretion over the pricing of the claim, sole discretion over the pricing of the network, whether they were going to pursue recoveries in the network, and all of those discretionary acts, they took the position that even if they disclaimed it in the paper, they were, Blue Cross Blue Shield was operating as a functional fiduciary because they were functioning in a fiduciary capacity. So still working its way through the courts, stay tuned on that one. But the important thing is that the government has weighed in and said that they're a fiduciary. So there's some shared fiduciary obligations. The second case is Bricklayers versus Anthem. It's a class action that was fairly recently filed. The Bricklayers, the complaint sounds very, not similar, but similar type claims. There were, say that there were overpayments, payments pursuant to the wrong fee schedule, payments over billed charges, etc. Anthem hasn't yet filed a response, not that I'm aware of, or a motion to dismiss. But in this, so this case is really, I think, going to be instructive because again, it's post CAA. But one of the positions taken by the Bricklayers, I think, for this audience is really telling. In paragraph 9, the Bricklayers essentially say, we are suing Anthem for doing these things as a fiduciary, because if we don't, our members are going to sue us. So they're taking the position that if they're not proactive and making sure that they're getting access to their data and they're being, engaging in financial oversight over their claims, if they don't do that, they fear that they're going to be on the receiving end of a lawsuit from their union members, which I thought was really, bold and an insightful thing to say, especially in a legal pleading. So again, stay tuned on both of those. I write on both of these in my blog, which you can look at on versanconsulting.com. So more to come. Next slide. All right, so I've thrown a lot of scary things at you, right? So don't worry, I don't think anybody in the room is going to get sued in the near future, but there are some real risks and obligations, but they're absolutely, can be turned into opportunities and, opportunities from risk to reward. By leveraging the data that you now have access to and have a legal right to, you can purchase healthcare smarter. You can be a good steward of your employer and employees' money. And, you can really bring healthcare transformation to the marketplace with this radical focus on transparency and accountability. Next slide. Okay. Christin, can I do a time check?
Absolutely. I think you have a few minutes. So
Okay. Yep.
Okay. You're good. You have quite a bit of time. So.
Okay, good. These are some examples, and this is more like the workshop, I guess, piece of the talk, because I struggled, having been in your seats, with going to conferences and hearing these sort of philosophical speeches about, you name the thing, but what I really need is some practical advice. Like, what can I take with me back to my desk tomorrow and put into place to start taking action and doing the thing that you're talking about? So that's what this is, right? We're going to identify, examples of fiduciary undertaking, do an ASA mock agreement review, et cetera. So let's jump in. Next slide. Yeah. So here I have an example of something that I regularly undertake. And on the left-hand column are those 5 fiduciary principles. So act solely in the interest of the plan, carry out duties prudently, et cetera. And the middle column is sort of a list of what actions are required of me as a fiduciary in order to execute on that principle. And then on the right-hand column, I have some examples for health plans, because, the fiduciary principles can apply to, like you said, the 401k space, the pension space. Anytime you're exercising discretion as a trustee over a pot of somebody else's money, you're acting as a fiduciary. So as applied to health plans, that's what the third column is. I'm not going to read these, but I have pulled out one specific example on the next slide. Just made it a little bigger so that we can look at it. This is just an excerpt. So as an example, act solely in the best interest of the plan and plan participants. What action is required? Everything I do has to be for the exclusive benefit of the plan. This means that I have to disclose and avoid all conflicts of interest. For a health plan, what does that mean? This is a good example of putting the compensation disclosure into practice, right? You have to look to all direct and indirect compensation from all vendors to both discover and then enforce, conflicts of interest restrictions. So an example of a breach, right, would be if you contracted with a vendor who either failed to disclose or failed to sign an attestation, or, and wouldn't give it to you, or signed an attestation and disclosed to you, and this wouldn't necessarily be a breach, but let's say a broker disclosed to you that they receive a bonus for keeping, your lives with a particular broker or a particular carrier. That disclosure, it's not going to automatically tell you you can't work with this broker, but what it does is it opens your eyes to say, when I'm evaluating carriers, I really need to understand and know that that broker has an interest with me staying with that particular carrier. So maybe I'm going to discount his recommendation that I moved with that carrier, or maybe I'm going to seek unconflicted advice to sort of confirm what they're suggesting. Again, it's all about the transparency and knowing where some of these conflicts arise from. Next slide. Another example would be, holding plan assets in trust. What does that mean? So, plan assets include all participant and beneficiary contributions, anything withheld from the member's paycheck for benefits, and then any rebates, refunds, dividends, or MLR rebates that come back as a result of those, that plan. So I think it's here, putting that into practice, you should very clearly identify what plan assets should be held in trust, and you should document the policies and procedures that you have in place to ensure that what is coming out of that trust account is only, again, for the sole and exclusive benefit of the plan. So here, an example of a breach of this principle would be giving a third-party administrator or a carrier carte blanche authority over an account with member contributions in it, with no accounting or audit oversight. So if your carrier or TPA has access to or is able to dictate to you the funds that are spent out of that trust account, yet you have been limited to the oversight functions that you're able to perform. Let's say, no, you can only audit 250 transactions that we select. I would think that that is unreasonable, and it precludes your ability to engage in the type of oversight that you need to do in order to ensure that plan assets are held in trust. Next slide. So this is an example of an ASA agreement review. So we're kind of on to like the second example, if you will, of how to take this concept and put it into action. The top axis is, again, the 5 fiduciary principles, so the top axis in white. And then on the left axis is various sort of buckets, if you will, of common contractual provisions that are in typical ASA agreements. So this is an example of an ASA agreement review. And again, it's an example, this would probably be many pages long if we were doing this exercise for real, but it's a good framework for you to take back. So the first bucket, restrictive language, and I'm just going to walk through a couple. We're not going to do the whole thing, but restrictive language on proprietary information. So, the rate, this is where we're talking about allowed amount, billed amount, paid amount, all of those things that you should be getting access to. So restrictive language on that. Does that restriction violate any of these fiduciary principles that you see along the top axis? And so you do a walkthrough. I would say it's not compliant, so it's sort of in the negative, because you have no ability to determine whether your carrier is following through with the exclusive benefit rule. The lack of data limits your ability to engage in prudent and informed decision-making. Following plan documents, I'm kind of neutral on that. Does this restrictive language limit your ability to hold plan assets in trust? Again, I'm asking it in the wrong way, but it doesn't satisfy that principle because there's a lack of data and financial transparency, which precludes the confirmation that assets are held in trust. And then finally, you can't assess reasonableness of payment if you don't know what the payment was and what the original, billed amount was, et cetera. So restrictive language that you've agreed to would violate many of the fiduciary principles that you should be abiding by. I'm trying to think, let's do as another example, because again, I don't want to walk through each of them, and you have this deck so you can peruse at your own leisure. Recovery discretion. So recovery discretion, most of you probably have recovery services as part of your ASA agreement. Essentially, if an overpayment is made, or perhaps a duplicate payment is made in error, your TPA generally retains the discretion of whether or not they're going to recoup that overpayment, how they're going to recoup that overpayment, and when you're going to get that repayment back to your self-funded account, if indeed you ever get it. So recovery discretion. If we walk through this exercise, does it satisfy the first principle? No, because you have no ability to recover your plan assets when appropriate. So if an overpayment is made, I have an example that I could use, that, there's a $1.3 million overpayment to a hospital. I, as the health plan administrator and fiduciary to my members, I absolutely should retain the discretion as to whether or not I want to go after that money. So, sort of capitulating and saying, I'm going to outsource that discretion to a carrier, I think that's problematic. You should retain some of that discretion because we're talking about a lot of money here. Recovery discretion, as you walk along, carry out duties prudently. I mean, somewhat neutral, follow plan documents, neutral. Can you hold plan assets in trust if you have outsourced your recovery discretion? I don't think so. I think that the lack of data and financial transparency precludes you from confirming that those assets are held in trust. And then lastly, pay only reasonable plan expenses. To go back to my first example, which, by the way, you can read about in Bloomberg, if you like. While I was at the state of New Jersey, there was a claim overpaid, quite literally overpaid by $1.3 million. If you have an inability to go back and recover that, I mean, I don't think paying $2.1 million for a $675,000 claim is reasonable. I don't think a court would find that to be reasonable. But you can't assess reasonableness if you don't, number one, have the data, and then number two, retain the contractual authority to engage in that recovery discretion. So, we could go through this exercise with all of them, but, you have the deck, you can do that on your own time. And there are other provisions in a contract that you can walk through this exercise with. And again, you document this. So when, if and when you are asked to produce the manner in which you have fulfilled your fiduciary obligations, you have some written work product, you have a thoughtful process in place, and it just sets you up for, to really manage that risk appropriately. Next slide. And then the last bucket, as an example, it allows you to engage in more prudent purchasing. So these are just some examples. Evaluate price on a unit cost perspective, not a discount. I mean, this is, I hope we're all moving away from discounts, but having the data will allow you to do this. Tie your performance guarantees to unit price trend, not to just medical trend and not to discount trend. Evaluate the quality of your network, not just the size of your network. Prioritize primary care directly to engage in like supply chain management. And I use supply chain management. I'm really talking about specialty care management downstream, and engaging in good primary care is a way to do that. Reducing variability in cost and quality. Next slide. as everybody knows on the call, because you are, sort of the birthplace of a lot of these tools that every employer in the country has access to, is benefiting from. There are a lot of tools for you, to help you achieve these goals. The SAGE Transparency Dashboard, the NASHP Hospital Cost Tool, they really give you some great ammo when you're challenged, and you will be, on changing the status quo. This data is really important. Why is it important? If I'm saving the health plan, let's use New Jersey for example. If I save the health plan $100 million through an initiative, $100 million savings to your plan is $100 million of somebody else's income somewhere in the healthcare industrial complex. So there will be others on the other side of the table that don't want to see your healthcare cost savings initiative succeed. But having this data as a backup and, sort of really is really key in having those discussions. Next slide. Identify allies. Again, especially if you think that you're going to face pushback in trying to achieve these goals. High quality providers, labor champions, employee champions, and organizational leadership. If you have procurement experts in-house that's not, that aren't working with you directly in your health plan, C-suite, and then obviously organizations like this where you interact with peers and do peer learning amongst each other. Next slide. And prepare for foes. Like I said, legacy carriers, this type of model and approach to healthcare purchasing and managing by the numbers is a new concept, and it will feel uncomfortable. But I think it's the right kind of uncomfortable. Low value provider organizations, conflicted consultants and brokers. This isn't, all consultants and brokers. What I'm saying is those that are conflicted, whose recommendations and advice are skewed by the financial system that is part of their business. It has to be disclosed so you can make decisions with eyes wide open. And then just, the internal politics of change management can be hard. And I think we all know that that is no different and probably more so in healthcare. Next slide. That concludes my formal presentation. I know it's kind of a lot to try and fit in and all that time, but I really appreciate it. You can see my email right there. If you have any questions, feel free to reach out, or you can reach out to Gloria and she knows how to get hold of me. But thank you so much for the opportunity.